my name is Simpson. I'm an associate with the law firm Tully Rinckey, where I focus the majority of my practice in military justice. As a brief introduction of myself, I spent nearly 8 years on active duty in the Marine Corps as a judge advocate, and there most of my time was spent also in military justice, so handling mostly criminal matters and administrative separations, as I will talk to you about today. I've been both a prosecutor and a defense attorney on active duty in the Marine Corps, representing Marines and sailors. More than that, I've also been a victims legal counsel, which is something new and unique to the military over the last 10 years or so. And as far as I'm aware, there really isn't quite the equivalent in the civilian world, where I represented the legal rights of the alleged victim in sexual assault, sexual harassment type cases during the court-martial process. So I've had a pretty unique perspective and experience with military justice. And I most recently was on active duty up until about May, just a few months ago, which is why my hair is this long and has not been this long in over a decade. So if I'm doing this, it's because I'm not used to touching my ears, which is definitely out of regs in the Marine Corps. So that is a brief introduction of myself. I appreciate you all being here today. And what I'm going to do is talk about an overview of the process. So this, of course, is not meant to make any of you subject matter experts in this area, not at all. And it's also not legal advice. This is just an overview of what it looks like, how it's set up, and what you can typically expect. And throughout this whole process, because my experience is as a Marine and in representing Marines and sailors, I may default, without even realizing it, to saying Marine, sailor. But know that I'm talking generally about all service members. And know that you may have yourself gone through the administrative separation process or are about to, or know someone who has. And I might say something and you might start jumping up and down. No, that's not what I saw or heard. And you might be right, because it depends. It's always case by case. And then a lot of different things depend on the branch of service that you are in. For example, we say like the Marine Corps might have someone who's the government representative as the recorder, and they're not a lawyer. And I'll talk more about that in a little bit. And I believe in the Army, that might be unheard of. Like, of course, it's going to be a lawyer, certified licensed person of the bar of a state that represents the government in an administrative hearing. But it's not always the case, and it always depends. And I'll be happy to answer any questions that I can at the end of this presentation, but just know that it might be caveated with, it depends. So here are the objectives for today. As I said, I'm going to talk about what may lead up to a board, what I've typically seen in my experience, and what the board itself looks like. How did we get there? Do you automatically rate the hearing? Not everyone does. And then what are your options after the board? Like immediately after, say you get a negative result, that you are going to be separated from Marine Corps, Army, whatever it is, what can you do? And then let's say you were separated years ago and you're thinking, maybe it's been long enough, maybe I can get my discharge upgraded. And I'll talk about a little bit of an overview in that process as well. And in talking about my experiences, what I've seen both as the recorder and talk about terminology, and as a defense lawyer, I'll tell you what I've seen as certain pitfalls if you are accused and become a respondent in such a hearing. And sometimes you are pressured to waive away your rights. Sometimes certain waivers are good, sometimes they're bad. It all depends on strategy. It depends on your individual case. And then there's also, of course, very serious considerations if you've been in 16, 17, 18, 20 years, and then you have your retirement to consider. So very beginning, I'll take a step back and talk very briefly about why we have this process and why is there a separate military justice system, not only for criminal matters, but for administrative matters as well. And it's important because this process, it's different than employment in the civilian world. For example, if you have a job at Walmart or a paper company, whatever it is, being fired there, of course, is very serious. You're losing income. Depending on your field, you might not get a letter of recommendation for your next job, and that might be important. But when you're fired from the military, quite often you are placed in a position where you are far worse off than had you never joined in the first place. So that is why this is important. Why I have underlined that they're good order and discipline. because you will hear that a lot, especially from the government representative, of why you, the service member, should be separated, because it is negative, it's contrary to good order and discipline. I've heard phrases like, this sailor is a drain on the unit. And is it the case? Is it actually contrary to good order and discipline? A lot of times it's not. A lot of times that's a line that they throw in there as a catch-all, saying, hey, even if you are on the fence whether this guy should be separated, think about good order and discipline. And what does that mean exactly? And one of the things that is important to note with the whole military justice system, that is the entire purpose of it, is good order and discipline. I mean, if you were to take a look at the manual for courts martial right here, it even says the purpose of military law is to promote justice and to assist in maintaining good order and discipline. Now, it's important to keep in mind, because a lot of times that the government representative and the board members might have those blinders on and forget that the person that is the respondent is themselves, he, she, a human being, not just another uniform, not just a name or a statistic on a page. And they have to get rid of that number, that statistic, in order for good order and discipline to be upheld. So if you have a good defense counsel, be it the uniformed kind or one civilian like myself, they should be pointing that out to the board. Now, a couple of different vocabulary terms I'll discuss. So because administrative separation hearing is not a trial, it's not a criminal trial, you're not called the accused, you are the respondent. So you are responding to the commander's recommendation that you be separated or essentially fired. So you rate a defense counsel free of charge, think of like a public defender, and also if you so choose, you can hire a civilian attorney at no expense to the government. And I'll go over a couple of points of why that might be a good idea to do in addition to the free lawyer that you get. Now, you heard me say the word recorder a couple of times, because the government representative is not called a prosecutor in this hearing. They are there to record the proceedings. And depending on the branch, like I said, everything's going to be with an asterisk, depends. They themselves might not be a lawyer, depending on what the allegations are. In some cases, they are required to be, in others that they're not. And the norm in some branches, say the Marine Corps, I've seen where a gunnery sergeant, E7, E8, somewhere around that rank, is representing the government, or a warrant officer, and that's their sole job. So it always depends. Now, court-martial, of course, as I said, it is not a court-martial, it's not a trial, but it kind of looks like one, in a sense, and we'll get to that. The separation authority is the person that is making a recommendation or going to say you will be separated or not, and what characterization of service that you will be getting. And the legal advisor, this is a role that I've had as well. So a legal advisor is a lawyer, a judge advocate, separate from the process. So if both sides, defense and the recorder, have an issue about whether or not something can be done, said, included, they can go and turn to the legal advisor, who's supposed to be independent and unbiased, and have nothing to do with the case or know anyone, and make a final decision. So that's a role I've held as well. And then you see members and senior members. I'll talk about that in a little bit as well when we get to the composition of the board. But another step back of what gets us there. And it's fairly straightforward in terms of the very beginning. As you might think, there's an incident, there is an accusation, and then depending on what it is, it could launch an investigation. It could be at a low level, a preliminary inquiry or command investigation, where commander designates a lieutenant, captain, whoever it is, say, hey, you have 3 days, you have 30 days, depending on the scope, to look into something and say, should this be, make recommendations as to what happened? Or if it's something more serious right off the bat, say assault, things like that, it might go to the Criminal Investigation Division. It might go, in the case of the Navy, NCIS, Naval Criminal Investigation Division. From there, it's up to the commander, depending on what it is. He can either take no action, do counseling, reprimand, and then you can go straight to administrative separation, non-judicial punishment, or Article 15, or court-martial. Now, if you're looking at the slide there, top right corner where it says no action, right below it's counseling. You think that doesn't sound bad. It is one step above no action, and no action is great. That's true. So counseling can be verbal, but where you might want to start getting concerned or to kind of pay attention is if it's a written counseling. A negative written counseling in the Navy, Marine Corps, it's called 6105. Now, basically what it is a piece of paper that says, we believe you did X, Y, and Z, don't do it again. And hopefully that's it. Hopefully that is just a written slap on the wrist. You go back to your job and everything's fine. But where you start to run into trouble is if you get more than one. That can create a pattern, or what the government will call a pattern of misconduct, and we'll get to that in a little bit as well. So the typical types of administrative separations when it comes to misconduct. Now, there are many types. There are types of administrative separations that do not involve misconduct. It could be mental health, things like that. But here today, just focusing on misconduct. But if there are any questions at the end, I'm happy to take them and discuss any other options for administrative separation. So as I said a moment ago, pattern of misconduct is probably the most common that I have seen in my experience, that and commission of serious offense. So when it comes to a pattern, I'm sure we've all heard the phrase, 2 is a coincidence, 3 is a pattern. Not here. We skip right to 2 as being a pattern. So if you have 2 documented incidents within the same enlistment, so if you are in your second enlistment and then you have negative counseling in one, negative counseling in the other, that doesn't count, generally speaking. So if you're in your same enlistment, you have 2 document incidents of misconduct, be it a negative counseling, page 11, non-judicial punishment, Article 15, you now have what is called a pattern, and you can be administratively separated, or the process can begin to separate you for that. And it could be very minor misconduct, and I have actually seen it, where a soldier, sailor, what have you, is late. They miss their formation by half hour, whatever it is, and that person's platoon commander, whoever it was, does not like you. They could have just done a verbal warning, like, hey, don't be late again. But no, they had the option within their authority to write you up and give you that negative counseling, that piece of paper. Then if it happens again, 15 minutes late, you now have a pattern of misconduct, and technically the process for administrative separation can begin. Now, it's not the typical. I mean, that's a kind of an extreme example, but I have seen minor misconduct like that be part of the basis for a hearing. And also the next step above that, most common, is a commission of a serious offense. Basically what that is think, could you be court-martialed for it? Can you receive a punitive discharge? That means a bad conduct discharge or a dishonorable discharge. Think theft, assault, things like that. And there are reasons why it's not a court-martial and why it's administrative separation instead, and we could talk about that, and I'll get to it. But that is the 2 most common that I've seen that go to a separation hearing: pattern misconduct and commission of a serious offense. Now, before I get into this slide where we talk about what needs to happen during a board, take a step back and describe the board itself. Because I said it is not a trial, though it sort of looks like one, because the government recorder, it could be a lawyer, could be a prosecutor, is there. They present the government's case. And then, of course, you have your attorney. It's the detailed defense counsel, either the one in uniform, plus, if you so choose, you hire a civilian, then they can work together. So then there's not a judge, there's not a jury, but there's a panel of 3 members. And they're not lawyers. They're not judges. More often than not, that might be their first time participating in such a hearing. They decide, basically, the questions that we'll get to in a second, but it's composed of a senior member and 2 other members. The senior member, from what I've experienced, is usually, at the very least, major. The E4, I've seen lieutenant colonels, E5s, and then senior enlisted. It could be E7, E8, sometimes an E9, and then maybe a junior company grade officer, lieutenant, or a warrant officer, something like that. And it all depends. It depends on the respondent's rank. So if you're a sergeant, at the very least, if there's a sergeant on the panel, they have to be senior to you in time and grade. So no one can be junior to you and be a member of a panel that decides your fate. So that's one of your rights. So the members will decide really four questions. The first, is there a basis for separation for the discharge? What basis is essentially the accusation. What do they claim you did or didn't do that is a violation of the UCMJ or some order or regulation? So is there a basis? And the government presents their evidence. The way it's set up, and like why I say it looks similar to trials, because there's an opening statement where the government says, here's the evidence that I'm going to present, here's the witnesses, this is why PFC Smith got into a bar fight, committed assault. His conduct was contrary to good order and discipline, and therefore should be separated. And then your attorney gets up there and gives him the old "my cousin Vinny" defense, as in everything that guy just said is absolutely not true. Now, those of you who've seen the movie know my language. I'm kind of curbing it. Vinny's language is a little more colorful. And we'll talk about burden of proof as well in a minute, but basically, defense attorney gets up there and they have options of what they could do, depending on strategy in your particular case. They could say, here are the evidence and witnesses that I'm going to present, or here's why the government can't do what they're saying they can. They can't meet the burden of proof. And then both sides present evidence. Witnesses are called, go back and forth, and there's a closing arguments by both sides. And then the members, which kind of look like a jury, make a decision. So if the members decide, yes, we believe you did it, and we'll talk about the burden and what requires them to make that decision, they think you did it, then they decide whether or not you should be separated. And when I say decide, what I really mean is they make a recommendation to the separation authority. And the separation authority cannot go down from what the board recommends. If the board recommends you receive an honorable characterization of service, separation authority can't say, you know what, no, I'm going to give them an other than honorable. We'll get to those characterizations in a minute as well. So they make a recommendation. If they recommend that service member be separated, then they have to decide how that separation should be characterized. There's honorable, which is, of course, top option, what everyone wants to get on their way out. Then there's general under honorable conditions. And then the third option is other than honorable. Now, someone hearing that from the very first time, you're like, what? What did he just say? Because it all sounds exactly or very similar. It's almost the same, but they're not. They have very serious consequences for each, depending on which you get. So after they decide, the board members decide that, then they have the option of deciding, should this recommendation for separation be suspended? As in for 6 months, a year, whatever it is, depending on your branch's regulations. Say if PFC Smith doesn't get in any more trouble and is serving honorably, after a year, this is no longer hanging over his head. They can make that recommendation, though the separation authority doesn't have to follow it. So if the members say, yes, we found the basis was met, he should be separated with an other than honorable characterization of service, but we recommend it be suspended. The colonel, the CG, whoever the separation authority is, can say, thank you, but no, I'm separating him. So there's a caveat to what the separation authority can do and go worse than what the board recommends. And before we get into characterization of service, I will talk about who gets a board, because not everyone gets a board. If your commander is recommending you receive the other than honorable characterization of service, the third, the worst option, then you get a board. If you have 6 years in service or more, you get a board. If you were a sergeant or E5 and above, you get a board. You get a hearing. You get to present your case with your attorney or more than one attorney to these members in order to present your case and have a proper defense. But if you don't meet those requirements, you could receive what's called a short form or a short form administrative separation. If your commander wants to recommend a general under honorable conditions characterization of service, they can do that. And then you don't get a hearing, you just get notified, and then you were on your way out. That is, of course, if you don't meet the other two requirements, if you're less than 6 years or if you're E4 and below. So not everyone rates a board. And then there are circumstances where processing, the beginning of the administrative separation process, is mandatory. It must begin. A lot of times when we go back to that chart saying what happened, the incident, the accusation, was it relatively minor? Was it UA? Was it you missed curfew, talk back to your superior officer, things like that? That doesn't require the process to begin. There's certain other steps. There's the counseling, opportunities for rehabilitation that must occur first. But there are circumstances where there's no options, no discretion. The process has to begin. And that are examples of drug use or illegal drug use. Say, for example, marijuana, you test positive on urinalysis, or cocaine, and any other controlled substance that you could think of that you were part of a command authorized and lawful urinalysis, and the results come back that you had a controlled substance in your system and you weren't supposed to. Then the process has to begin for administrative separation. And then the same with sexual assault. allegations like that. But mandatory processing doesn't mean mandatory separation. It doesn't mean necessarily that a board even needs to occur. And that is a very important distinction that your defense counsel, be it the uniform or the one in the suit, is making to the board members. Because more often than not, those board members, it's their first time doing it. They're brand new to the process, the rules, regulations. And if they hear a prosecutor, or excuse me, recorder, who could be a prosecutor, say processing was mandatory, then the members might think, well, there's a check in the box. Basis has been met. We don't need to worry about that. That's not the case. That's not true. Mandatory processing means just you have to look into it, investigate, and it may not even lead to a board, but it does have to start the process. So if your defense attorney is on top of their game, they're going to point that out to the board, that it was not necessary that they achieve or get to a board. And more than that, it's absolutely not mandatory that this sailor, soldier, airman be separated or even recommended for separation. So now we get to the burden of proof. So you may have heard from TV, movies, the phrase beyond a reasonable doubt. That is true for criminal trials, where someone's going to get a criminal conviction, and in this case, the military, either a bad conduct discharge or dishonorable discharge, and could potentially, depending on what that charge is, face jail time and all other punishments that go along with a court-martial. Because this is an administrative process, as in essentially, the phrase that you'll hear the government recorder say, a hiring and firing committee in terms of employment, that the burden of proof is lower. It's 51%, what's called preponderance of the evidence. More likely than not, did PFC Smith get into a bar fight? And of course, the government still has to present evidence because the government has the sole burden to prove it. The respondent is under no obligation whatsoever to do a thing. They and their attorneys can literally sit there, not say a word, and if the government has not presented evidence beyond that 51% or that preponderance of the evidence, then the members must find no basis. Now, is it a good idea and a good strategy to sit there quietly? No, it's not. More often than not, your defense attorney is going to put on evidence, going to present witnesses and make an argument. And absolutely should, but they're not required to. So even with all that, if the government is still not proven that PFC Smith got into that bar fight and punched someone else, then the members cannot find basis. But does that mean it's not a big deal? If you're not getting a punitive discharge, if you're not getting a criminal conviction, if essentially it's, are you getting fired? Is it, other than that, and obviously the ramifications of losing income and the stigma of I was fired, is it that big of a deal? It absolutely is, absolutely. And one of the things that you'll hear from the government all the time, at least what I heard, is like, oh, it's not those things. It's not a punitive discharge. It's not a criminal conviction. We're just here to see whether or not this PFC Smith deserves to continue his employment with the Marine Corps, the Air Force, whatever it is. And if you were to receive an other than honorable characterization of service, not a big deal. But it absolutely is. And here are there, as I said, there are three types of discharges that can be administratively given. Bad conduct discharge and dishonorable discharge are not on the table. Those two are not options. But I want to talk to you all about the other than honorable characterization of service, because other than the fact that you can't say for that specific enlistment you didn't serve honorably, your DD 214 doesn't say the word honorable, it says other than honorable, even though it's very similar sounding, and those in the civilian world might not know what that is. It might not affect your ability for employment, things like that. But if you're trying to be a police officer, federal, state, government employment, it absolutely could affect it. But in terms of what benefits you rate, an OTH has some serious ramifications, and it's actually incredibly similar to the bad conduct discharge, to the punitive discharge that you can get at a court-martial. So obviously, the first course of action, everyone's honorable. Then there's general under honorable conditions where you will still receive quite a bit of benefits. You do. And you can petition for others when it's to be determined. But when you look at other than honorable, it's practically the same as the bad conduct discharge. And taking a look at the slide here, hopefully it's not too blurry. And there's a lot of information on there. I didn't put this here to show you or to have you read every single line. But if you look at the highlighted portions, these columns, Charlie and Delta, they outline what you rate in terms of benefits for other than honorable characterization of service compared to Delta column here, bad conduct discharge. If you look at it, almost identical. A couple exceptions, but it's almost identical. So you were losing out on quite a bit. This slide here, Montgomery GI Bill, not eligible. Same thing with bad conduct discharge. One thing that I use effectively in arguments, I believe, when I was a defense attorney representing sailors and Marines in administrative separation hearings, is really outlining how serious the OTH, other than honorable characterization of service, really is. Because it is not like you're just being fired. Because you are being placed in a position where you are far off worse than you were had you never joined in the first place. Look at here. If, God forbid, you were to pass away, your family cannot automatically put an American flag on your casket, even though you served. Not automatically. They have to petition and try to get that approved. But that's how serious it is. They say the misconduct, even though administrative, was so serious that you don't get a flag on your casket, even if you served like 99% of your first enlistment honorably, but then something happened and you were separated. That's one of the consequences. That's why it is incredibly serious. And it's not the same as saying that it's not a big deal. It's just essentially an employment board. And another very, very important consideration is that a lot of our service members in this country are not U.S. citizens, and that they're using their service to go through the process to become naturalized citizens. I remember one of my duty stations in Okinawa, Japan, that I was able to witness many like Marines, some of which my Marines, become U.S. citizens. It's an incredible moment, and they absolutely earned it. But after all those years of serving, do everything you possibly can to protect and defend our nation, be a Marine, be a great service to your branch, but then something happens, and then you're not a citizen, and you didn't get through that process before this allegation, this misconduct occurred, it might have some serious effects on your immigration if you are trying to become a naturalized citizen. So it is incredibly important that when you go through this process, that you're not just thinking, you know what, screw it, I am getting administrative separated, I don't want to be here, there's no chance, I'll take whatever they give me, I'll take the OTH. Take a step back and know that a lot of the service members don't know about this. I mean, this particular example that I'm giving you, these charts are from the Marine Corps Separations and Retirement Manual, as Appendix K. What PSC Lance Corporal is looking at this manual? Hopefully, possibly, like if they are accused of something, but then their attorney should be going through this. Sometimes it's strategic. Sometimes it is a good idea to waive your board for other considerations because there might be court martials involved, things like that. But like I said, everything is strategic and it always depends. Depends on the particular facts of your case, depends on the branch of service and what your goals are later on in life. But just know that other than honorable characterization of service, it's practically the same as a bad conduct discharge. One's punitive, one's technically not. Like I said, you go into the civilian world, someone who has no affiliation with the military experience, they might not know the difference. You might treat it the same, or you might be okay. But you are incredibly limited on what you can do with the OTH, and is practically the same as the bad conduct discharge. So let's say you get a negative result. You go to the board, you present your case, and they still say, yes, there was a basis, and we believe POC Smith should be separated with the OTH. What are your options? The very first thing is you can try to write a rebuttal, what we call a letter of deficiency. And that usually covers two different things, generally speaking. First, was there an error in procedure? Something went wrong, your rights were violated, as in you had the right to call witnesses, but then you refused that right. That's an extreme example. That doesn't really happen, but that is an example. You put that in the letter of deficiency. Or the board members are all part of the same unit. The senior member is the reporting senior to the lieutenant. So there's reason to believe that the lieutenant might have been just going along with what the major said because they're in the same chain of command. Like that is absolutely something you would put in letter deficiency and say this board either needs to be redone or you got to throw out the results because there was either an actual bias or perceived bias or an injustice happened and there was a procedural error or something like that. And then you can put together a package and then submit it and hope for the best. Usually, I have seen it very rarely where a board recommends one thing and then the separation authority does something else in terms of recommended OTH and then say, I'll give them a general, give them an honorable. It happens. It's rare, but it does happen. So that's why the letter deficiency, the rebuttal package is important. It does mean something and it's worth a shot. And before you go to, say, a board for corrections later on, get to that in a slide just a minute, you're able to show that, hey, you exhausted all the different remedies, all the different options that you could have tried in order to get the relief, the OTH moved up to general honorable. And then now you're going to this board because you've already tried everything. Now, talking a little bit about the discharge review board. I have seen this often, both from the government and also I've seen it from other defense attorneys that are new, honestly, and from the government when it comes to discharge review boards, telling the members, hey, they always have the option of upgrading their discharge later on. You give him an OTH now, he'll be fine, he'll upgrade it. That's not how that works. Yes, you may have the right to petition the board, but it's incredibly difficult. It's not just a given, fill out some paperwork, done. Like you again have to show that there was an error, there was an injustice, as in the punishment that you received, the characterization is far excessive to what the actual misconduct was. So there has to be a reason for the board to upgrade your discharge. And the boards for correction military records, that is kind of like the next step up in that appeal process from the discharge review board. And mentioned earlier that this doesn't have to be an avenue if you've only recently gone up against the board and got a negative result. I currently represent clients that they are 10, 20, 30, some 45 years since they were separated. And once you get to the Board of Corrections, there are other things to consider. That you could possibly be granted clemency, like you've rehabilitated, you've done great things for the community, and there are other caveats. Like I said, I could do a whole week's worth of webinars on those topics alone. So those of you watching, if you are under those kind of facts that hey, it's been years, or maybe not, it doesn't have to be years, decades, and then you're trying to upgrade your discharge, or you think that is something you want to do, we can absolutely talk about that and see what we can do. And it's definitely an option. Should you waive your board? No, probably not. Like I said, there are circumstances where it's part of a plea deal. Let's say that you are being court-martialed, it's going to a trial, and then part of a plea deal, working with your attorneys, think risk of criminal conviction, I will waive my right to administrative separation hearing and be done. And depending on your case, that might be a good strategy. But if you are thinking, no, I just don't have a chance, I don't know what I could do, what evidence I could present, that's not the time to make that decision. If you're a service member currently active duty, you have the right to consult with a uniformed defense counsel. That was me. I did that quite often. We have office hours, you come in, and then we'll go over the paperwork, your facts of your case, and then help you make a decision. So the ramification, other than waiving your right to a board, which will almost always result in an other than honorable characterization, with some caveats, remember, it always asterisks, always depends, that later on, if you decide to go to the discharge review board, or for example, the board for correction of naval records, army records, whatever it is, it makes it that much more difficult to say, hey, I deserve an honorable characterization, but I voluntarily waived my rights and received the other than honorable. It makes it much more difficult. It's not necessarily an insurmountable thing, but it makes it more difficult. So it's always a good idea to consult with an attorney before you make that decision on waiving your board, if you are fortunate enough to be in a position where you rate the board. Now, of course, if you are close to retirement, then you are probably in a position where you're going to rate a board if the command's going to give you no TH, or even in general, they want to separate you. If you're close to retirement, that's 16 to 20 years, what have you, then you rate a discharge review board. And then you have quite a lot to lose, potentially, in terms of retirement pay later on. But even if you get to a board and they find basis, they say, yeah, we believe you did the thing that the government says you did, but we recommend retention. Great. That's not the worst result, obviously, for a board, but it also might have some ramifications for your retirement, because that may result in a great determination board. So say you're an E8, and you may, based off of any alleged misconduct, or if you admitted to something, it may determine what grade you actually retire at. Now, there's, again, many weeks worth of webinars we could do on that subject, but that's a very, very tiny little nutshell kind of overview. But then there's so many asterisks, so many what if this, then that, different requirements, different rights, things like that. So I won't get into that today, but know that don't waive your board, and know that if you're close to retirement, that there are some serious ramifications, even if they find that you should be retained within the service. And there are other considerations, not just if you're close to retirement, but if there was a criminal investigation, CID, NCIS, or whatever your branch's version of like the felony level investigators are, is that titling, meaning your name is on a criminal report saying that you are suspected of, you believe to be have done X, Y, and Z, assault, sexual assault, whatever it is. And even if the board finds later on that no basis, still doesn't change the fact that you might be titled, you might be listed as the suspect in that criminal investigation. And that's a whole other thing that has nothing to do with administrative separations. But that is something, if you consult with an attorney, you could go down an avenue possibly getting your name removed and expunged. That is its possibility. Just know that these are things that your detailed defense counsel either might not know about, or might not, or well, really might not, but actually wouldn't have the authority to help you with. Again, depending on the branch. And I'll get to that in a second. We'll get to it right now. So should I hire a civilian attorney? Maybe. As with everything, the answer is maybe. It might be a good idea, because what civilian counsel can do, it can in many ways exceed what your detailed defense counsel can do, and no fault of their own. It's like by law, regulation, statute, they can do X, Y, and Z. Like, for example, let's say you were under investigation. Federal agents, NCIS called you up, say, we want to talk to you because you are alleged to have done that assault, PSC Smith, you assaulted someone in the bar. You can go and get legal advice from the defense office, but you're not going to be assigned an attorney. Not until there are actual charges preferred against you. Now, that term preferred and referred, that, of course, with courts martial, that's a different subject, but know that unless there's a charge sheet, you're not getting assigned your own defense counsel, detailed defense counsel. So the civilian attorney, we can get involved right away. As soon as you retain us, we can talk to the commands, we can talk to law enforcement, like what is the investigation? We can advise you throughout the whole process. And that is something more that we are capable of doing, because that is our job. We have the time, the resources to do it, that your detailed defense counsel might not be able to do. And for example, there are other areas, let's say if you are being evaluated for possible medical separation, either disability, retirement, or if you're not eligible for retirement, but medical separation. That, again, that's a whole other week's worth of webinars. But just because you are in the disability evaluation system process, the DES, or the Medical Evaluation Board, Physical Evaluation Board process, does not mean you are protected from being administratively separated. It is possible, and I've seen it happen, where the service member is going through the process for potential either medical separation or medical retirement. And of course, with that comes all the benefits that medical retirements or regular retirements have. But if there's allegations of misconduct, as going back to the previous slides in that chart, that lead to an administrative separation, you could absolutely be removed from the medical evaluation process, and then be processed for administrative separation instead. I've seen it happen. It's absolutely a possibility. So getting a civilian counsel they may have the scope, or they will have the scope to actually start advocating on your behalf in that sort of situation, especially if that you're a person that you don't rate a board, like they're trying to give you a general under honorable conditions service, remove you from the medical evaluation process, and then be done. It's, I think, a great injustice, especially if you're already well along the way in the medical evaluation process. But again, asterisk, depending on the branch and what your detailed defense counsels or just defense officers are authorized to do, in that sort of scenario, they might not be able to do anything. Maybe help you with a rebuttal if, depending on the office and who's in charge and what they are authorized to do, they can maybe help you put a rebuttal package together. And I've seen it happen, and I've been in that situation where it's not much I can do because I'm not allowed as a detailed defense attorney. You bring in something to me, I can take a look at it. Like hiring a civilian, we can go in much more detail, much more work can go into your rebuttal package to hopefully convince the commander to keep you in the medical evaluation process as opposed to administrative separation. So there are the scope. And I will say that in this by no means is to disparage at all uniformed defense counsel. I was one. And a lot of times, if I were in trouble now, if I was still on active duty, I know exactly the person who I would call. It wouldn't be a civilian counsel, not necessarily. I know who this person is that I would ask them to defend me. They're absolutely fantastic, but they just can be limited in what they're allowed to do. They'd be incredibly skilled, but just limited. And kind of going back and what I said in the beginning, like who is going to be the prosecutor, the recorder, defense attorney, depending on the branch, depending on the unit, where you are. Administrative separations are sometimes given to the new guys. Defense, recorder, government representative, the ones right out of the schoolhouse that they need to get their feet wet, they need to get the experience. I mean, you got to start somewhere, but at the same time, depending on where you are, what branch, that might be what you're dealing with, and it might be a good idea to consider a civilian attorney in addition to the detailed defense counsel that you have. I know other places, like I said, I think maybe my Army brethren out there watching might be jumping up and down. So that's not the case here. And that may very well be true, where it's a seasoned attorney. That's all they do. It's their job. They are devoted to administrative separations. And that's fantastic. But like I said, there are a lot of considerations and a lot of things outside of the scope of one that's not outside of the scope of the other. And this has been 45 minutes of a general overview of the process, and this can go on and on and on. There's so much to talk about. It can be very nuanced with a lot of different consequences, a lot of severe consequences for a discharge. I have any questions?
If anybody has any questions for Stephen, please submit them in the chat and I will send them over to him to answer.
I think one of the pre-submitted questions was, I've been notified, what can I do prior to a board hearing if I'm going to get a board? That's a very good question. And what I would say and have said is very obvious. First and foremost, be on your best behavior. Because if you are accused of something, you are going to be under a microscope with your command. Do not give them a reason to write you up for anything. Not at all. And of course, if you were already doing well at work, fantastic, keep it up. I cannot imagine how stressful it is, the anxiety, the frustration that someone going through that process experiences. I, of course, can't imagine that. But know that board members like to see evidence of rehabilitation, as in they need to decide, or part of the recommendation is based on, do we want this person to continue their service in their particular unit, in their branch of service? And if you have, and the phrase I hear all the time is, if you have not dropped your pack, you're continuing to do good work, not getting any trouble, going above and beyond, that's great. It's great evidence. Those are the things you can do. Because unfortunately, there's not a whole lot more you can do to be proactive. Of course, there's things on the legal side that your attorney can try to do. But in terms of you yourself, it's basically that. So hopefully that answers that question. If there's any follow-up, I'm happy to discuss as well. Oh, yes, one thing I did not mention, one of the questions, is there a separate process for officers? Yes, absolutely. It's very similar looking, but for officers, it's called Board of Inquiry, and it's set up the same way whereas a recorder, defense attorney. Though when it comes to mandatory processing, like drug use or illicit drug use, sexual assault, things like that, mandatory processing, it's still the same. Like a pattern of misconduct, hopefully, like minor stuff will not reach to that level where someone is being processed out, but it's still pattern of misconduct still applies. So clemency, you can question about clemency. What is that? That again, it depends. It can be a combination of things of passage of time where you have been an upstanding citizen, you have been a pillar of the community, volunteer for organizations, and you've taken steps to rehabilitate. Let's say there was an incident and involved alcohol, that you've alcohol rehabilitation, treatment, things like that. It's an example. It doesn't necessarily have to be, but it's something that you could do. And that also, if there was a victim involved, if you've made amends, these are all, I'd say talk to an attorney before you do something like that, talking to an alleged victim, but those are things that would be considered in clemency. So the question is, you have to specifically request discharge review. Yeah, so after the separation, the board members make that recommendation. There is a legal review to make sure procedure is followed, signatures are on the dotted lines where they're supposed to be, and nothing, the response rights weren't violated, things like that. But when it comes to the discharge review board, yes, you will have to petition them. You can Google that for your respective branch. And if you need assistance, that's part of our practice here. We help assist with discharge review boards and boards for correction military records. So, but it's not like an automatic appeal process that you might see in a courts martial or otherwise civilian criminal case. Okay, I think that is just about it. I appreciate everyone's time and listening to me talk about administrative separations. Remember, everything always has that asterisk. It always depends on your case, the specific facts of the allegations, the branch of service, where you are, your rank, time and grade, all of that. Remember that the administrative separation process, although it is administrative and not criminal, it still has potential from some serious negative impacts on your life and your future. So take it seriously. Don't waive your rights. Always talk to an attorney, especially, or even if it's the detailed defense counsel, absolutely. Or if you want to consult with civilian counsel as well, please do. But regardless, talk to an attorney. Thank you.